In this lesson, we're going to go over the doctrine of justiciability and the case or controversy requirement under Article 3, Section 2 of the U.S. Constitution. So, if you'll recall from our last lesson, right, in Marbury versus Madison, we actually talked about Article 3, Section 2 of the U.S. Constitution in a little bit of detail. If you'll remember, right, this is the section of the Constitution that establishes the jurisdiction of the United States Supreme Court and the federal court system. Now, if you actually read the language of Section 2 as it's extending, right, as it's establishing this jurisdiction and extending that jurisdiction out, right, of the Supreme Court and the federal court system, it only extends that jurisdiction to cases or controversies, right? It's right there in the first sentence. If you read under Section 2, the judicial power shall extend to all cases in law and equity arising under this Constitution. It talks about cases affecting ambassadors, to all cases of admiralty and maritime, to controversies to which the United States shall be a party, to controversies to two or more states, right? It goes on and on talking about cases or controversies, right? As it's extending that jurisdiction out of the Supreme Court and the federal court system, right? It's only extending that jurisdiction to cases or controversies under Article 3, Section 2 of the U.S. Constitution, right? And this is really important because nowhere in the U.S. Constitution does it extend the jurisdiction of the Supreme Court to questions, right? To hypothetical fact patterns or to questions that might be presented by other branches of government, right? It only uses the language case or controversy. So really, our entire lesson today is a discussion of the interpretation of what they mean by case or controversy, or what does this mean, right? This case or controversy requirement under Article 3. And in short, what we'll see is in order for a federal court to issue a ruling, to hear and decide a case, there has to be an actual case or controversy, right? A real dispute between adverse parties, right? We can't issue advisory opinions based on hypothetical fact patterns, right? At least Article 3 courts can't, right? Courts that are under the jurisdiction of Article 3, Section 2 of the United States Constitution, which would be the Supreme Court and federal courts, right? So, taking a step back though for a second, right? If we think about issue spotting in the big picture for your purposes on a constitutional law fact pattern, when should you be thinking about the doctrine of justiciability and the case or controversy requirement, right? Well, any time that you have in a fact pattern a federal court that's going to hear and decide a case, right? You have to be sure that the federal court has the power or the authority to actually hear and decide that case under Article 3, Section 2 of the U.S. Constitution. And your first question really has to be whether this dispute or whether this question that's being presented to the court meets the case or controversy requirement under Article 3, Section 2. If it does, right, we say the case is justiciable, right? That's where this word, the doctrine of justiciability, comes from, right? If the case or controversy requirement is met, the case is justiciable, right? That means the federal court can actually hear and decide that case. If it does not meet the case or controversy requirement, we would say that's non-justiciable, right? The federal court does not have the authority to hear and decide that case, which means the federal court needs to dismiss it, right? Because it's non-justiciable. Okay? So again, big picture, anytime you see a federal court going to issue an opinion or hear and decide a case, you have to make sure that you actually have an actual case or controversy, a real dispute between two adverse parties, right? Which takes us to our first requirement, advisory opinions, right? Federal courts can't issue advice, right? Federal courts cannot issue non-binding opinions absent an actual case or controversy, which is really another way of saying federal courts cannot give advice to people based on hypothetical facts or thought-provoking questions, right? You can't just go to a federal court and say, hey, if XYZ happens, what are my legal rights here? You know, not based on any real dispute or an actual case or controversy based on established facts, right? So important to recognize, this is usually pretty easy to see, but the first thing you do want to recognize under the case or controversy requirement is simply that federal courts cannot issue non-binding opinions absent an actual case or controversy. We need a real dispute between adverse parties, right? And that dispute has to be based on an issue that a court can actually resolve. You know, it can't be an argument between two brothers, you know, who gets more time with the video game, right? It's got to be an actual case or controversy, a dispute that can be resolved by a court, right? Based with, you know, where we have two adverse parties. Okay, now the one thing to keep in mind is under the Federal Declaratory Judgment Act, federal courts may declare present rights on established facts arising out of a case or controversy of sufficient immediacy and reality, right? So you have this idea of the declaratory judgment, right? Federal courts can, under the Federal Declaratory Judgment Act, issue declaratory judgments, right? And declaratory judgments can sometimes look like maybe we don't have an actual case or controversy. But the key to remember is that as long as we have established facts and a real case or controversy, right? An actual case of controversy. We have a dispute between parties, right? Where litigation is pending or litigation is immediate or a reality, right? Then we say the federal court can issue a declaratory judgment, right? Which is going to declare the present rights of the parties, right? It's either going to establish who the parties to the action are or what their present rights are. So what I was trying to get at is sometimes it can look like a party's just going to a federal court and asking for advice, but they're not doing that. A declaratory judgment is different than just seeking advice from a federal court based on a hypothetical fact pattern. And the key is we still have an actual case or controversy of sufficient immediacy and reality, right? So the key to look for in a declaratory judgment fact pattern is usually something like a cease and desist letter. Imagine that, you know, and you see this a lot in intellectual property. Imagine that, you know, someone is infringing on a defendant, a potential defendant is infringing on a plaintiff's copyrights. So oftentimes what happens, right? The plaintiff is going to send that defendant a cease and desist letter saying, hey, look, you're infringing on our copyrights. You know, you need to stop doing that or we're going to pursue legal action, right? Well, when the plaintiff does that, when somebody sends a cease and desist letter, that's basically creating an actual case or controversy of sufficient immediacy, right? That person is now establishing, hey, look, we have a real dispute here. I think you're infringing on my legal rights. You know, if you don't do something, this is going to court, right? Well, that's now a real dispute that's arising, right? It's a very early stage of the dispute, but nonetheless, it is an actual controversy at that point of sufficient immediacy when that cease and desist gets sent out. So the defendant at that point, usually once they receive a cease and desist letter, would be able to go to a federal court and ask for a declaratory judgment to establish either their rights or, you know, seek out who the actual parties are, right, to declare the present rights. And this could be, you know, in that example, maybe the defendant's even questioning whether this plaintiff owns the copyrights in question, right? He wants the court to establish who owns the copyright. Well, he could go seek a declaratory judgment to do that, right? But the key is here, outside of that, is just recognizing that the requirement's still the same, right? We just need an actual case or controversy. You can't seek a declaratory judgment based on hypothetical facts. You can seek a declaratory judgment based on established facts arising out of an actual case or controversy of sufficient immediacy, right? A real dispute where, you know, something like a cease and desist letter has been sent, or we have a real contentious relationship where, litigation is pending, right? Then those situations, a party can seek a declaratory judgment, right? And again, we talked about hypothetical cases, right? If the facts aren't established, they're hypothetical, the federal court can't get involved. That's not an actual case or controversy. We need a real dispute based on established facts. And the other thing, though, to think about here with hypothetical cases is sometimes referred to as feigned cases, right? Federal courts cannot adjudicate a collusive lawsuit arranged by non-adverse parties. Remember, to have an actual case or controversy, we need truly adverse parties. You'll see whole lines of case law. Remember, this is only federal courts being governed by Article 3, Section 2 of the U.S. Constitution, but a federal court cannot adjudicate a collusive lawsuit that's been arranged by non-adverse parties. And what I was getting at there is, right, you have a line of cases where essentially the plaintiff and defendant kind of just get together, right? They have a problem with some sort of government action. So they know that they want to challenge this government action, but they don't have standing to do so, so they kind of invent a fact pattern between them, right? Where they create the fact pattern that they think they need to challenge this action. But really, the plaintiff and defendant aren't adverse, they're like buddies. They're usually like friends, and they just want to challenge this lawsuit, so they kind of fake a fact pattern, if you will. Anything that looks like that, where you actually have the plaintiff and defendant colluding together, right, that's not going to meet the actual case or controversy. We need a real dispute between adverse parties. Right there, that's not a real dispute. Those parties are non-adverse if they're colluding together, right? Federal courts cannot adjudicate those cases. State courts, right, maybe they could. They're not governed by Article 3, Section 2 of the U.S. Constitution, or that's not within the state's jurisdiction, right? Article 3, Section 2 doesn't talk about state jurisdiction. It's only talking about the Supreme Court and federal courts, right? This case or controversy requirement's only applying to the federal courts. Okay? Which takes us to the big question here, right, which is standing. When we're thinking about the doctrine of justiciability and the case or controversy requirement, these three elements that you see up here on the board are the meat of the analysis, right? What you'll always want to run through. So again, anytime you're looking at a constitutional law fact pattern where you have a federal court that's going to hear and decide a case, right? You want to make sure that the plaintiff has standing to bring this action to the federal court, right? A federal court cannot adjudicate a case unless the plaintiff has standing. And to have standing, right, the plaintiff must establish three elements. We're going to say injury in fact, causation, and redressability. So we can break each of these down a little bit with some case law, some of the seminal cases here. So number one, right, the plaintiff needs to have experienced a concrete and particularized injury, right? The injury the plaintiff experienced must be concrete, right? Threats of future injury can constitute injury in fact, but the threats of future injury must be actual and imminent, right? So probably the best illustration and kind of the seminal case in injury in fact is going to be Lujan v. Defenders of Wildlife. If you remember in this fact pattern, right, we basically have an environmental protection law that is passed, right, that's going to protect endangered species, right? And this law not only extends in the United States, but it also extends to foreign nations, right? So the government is going to do certain things to make sure that they're complying with this law, not only when they're taking actions that could affect the United States, but also actions that could affect foreign nation, right? Endangered species in foreign nations. Well, about a decade later, right, the Secretary of the Interior actually limits the scope of this law and says, look, we're not going to have this law extend outside the jurisdiction of the United States. And essentially, Defenders of Wildlife, which is an environmentalist group, challenges this limitation on the scope, right? The government action, the Secretary of the Interior limiting the scope of this law, the jurisdiction kind of the law from foreign nations and the United States to just the United States. Of course, Defender of Wildlife, this organization, wants the law to not only apply to actions taken in the United States, but to foreign nations as well, right? And the problem for Defenders of Wildlife, right, this case gets dismissed because Defenders of Wildlife don't have standing to bring this action, right? They haven't actually sustained a concrete and particularized injury in this fact pattern, right? Now, Defenders of Wildlife alleges that, hey, look, right, this law not applying to foreign nations just damages the environment and the ecosystem at large, which harms everybody, including us, right? A damaged environment, a damaged ecosystem, you know, this effect on endangered species affects us all in different ways, right? When species go extinct, this can have huge impacts on the food chain, all this stuff, right? And the court says, yeah, maybe, but, you know, that's way too speculative and it's not particularized or concrete enough, right? When we're thinking about injury in fact, we're thinking about concrete, right? I mean, think of a pedestrian crossing the street, right? They're crossing the street right on the crosswalk, and a driver who is, you know, texting while driving is distracted, slams into the pedestrian, and the pedestrian breaks their arm, right? I mean, that is a concrete and particularized injury, right? I got hit by a car, now my arm is broken, right? And now I have to pay $100,000 in medical bills, right? There's economic loss, there's, you know, physical pain, right? And not to say that an injury has to be economic or physical, but those are going to be evidence of very concrete and particularized injuries, right? So it could extend to things like, you know, mental anguish, distress. There's all kinds of injuries a person could sustain, but when it gets that generalized, like it is in Lujan v. Defenders of Wildlife, where you're basically just saying, hey, look, the environment here is going to be damaged, we're going to lose these endangered species, right? And that affects everybody, including us. That's not a concrete and particularized injury, right? And there too, they kind of argue, well, you know, we have plans to visit these foreign countries and observe these endangered species, and, you know, that's going to cause us injury. Again, the court just rejects all of those arguments and says, look, if you have plans to go visit these foreign countries where these endangered species are, and you can show concrete plans to do so and how that's going to cause you a concrete injury, you know, we'll hear it. They don't exclude the idea of a future injury, but it has to be actual and imminent, right? And they can't show that they have concrete plans or how they would have a threat of an actual and imminent future injury. So for this reason, this case is dismissed because the plaintiff lacks standing because they've sustained no injury in fact, right? And just a common thread you'll see, this idea of a generalized grievance is almost never going to work, right? If a government action affects people at large, right, and a lot of people are affected, that doesn't necessarily mean you yourself haven't sustained an injury, but you have to show how your injury is concrete and particularized. Just because an injury at large is sustained by lots of members of the public, it doesn't mean by that fact alone you don't have standing, but you still have to show that you yourself, this plaintiff, has a concrete and particularized injury, right? That's element number one of standing, right? And the plaintiff has to establish this to bring a case to federal court. Look, number one, injury in fact. Number two would be causation. So once they've established injury, they have to show that that injury is fairly traceable to the defendant's conduct or action, right? So think about the car accident scenario, right? That's a very easy causation problem, right, to analyze, right? I'm walking down the street and I'm going across the crosswalk. A driver's looking at his phone and slams into me. Right now I have a broken arm, okay? My injury, the broken arm, is very traceable to the driver's conduct of looking at his phone, right? The driver's looking at his phone, he's not paying attention, he slams into me, the collision instantly breaks my arm, right? that injury, my broken arm, is completely 100% traceable to the defendant's conduct, right? Texting, not paying attention, and slamming into me, right? No causation issue there. But when we think about causation, it's not always that straightforward, right? And if you remember from torts and cases like Pausgraph v. Long Island Railroad, it's a similar idea, right? The further that causal chain gets extended, the more attenuated that causal chain gets, right, the harder it can be to trace the injury to the defendant's conduct. And in constitutional law, where you see problems in standing, are often in lines of cases where the plaintiff is suing the IRS, right? So from time to time, this fact pattern, the way this typically plays out, right, is the IRS is going to have policies in place to either incentivize or disincentivize certain actions, right? Maybe one of the easiest to see, just to take an example, would be donations, right? Charitable donations, right? If you go and donate books or clothing to Goodwill, right, at the end of the year, you can deduct those charitable donations from your federal tax return, right? The IRS does this. They allow you to deduct the fair market value of those goods from your federal tax return in an effort to encourage people or incentivize people to donate clothing and books to Goodwill, right? Very straightforward. Now, what would happen though if the IRS changed this policy? They say, hey, look, we're going to decrease the amount you can get in these deductions to 10%, right? So whatever the fair market value of the goods you donate is, right, you can only deduct 10% of that value from your tax return. So if you donate $100 worth of clothing and books, you get to deduct $10 from your tax return, right? And say that this causes people across the country to donate less books to Goodwill, right? Well, say that you have a plaintiff, a prospective plaintiff who's a law student, right? Doesn't matter what. And he's relying on these books at Goodwill to study for his final exams and get through law school. Well, now after this policy's gone into effect, there's less books at Goodwill. So now this plaintiff can't get the law book he needs to prepare for a final exam. He fails the exam, right, and gets kicked out of law school, right? And now he's lost income opportunities, he's in debt, right? So this plaintiff has injury in fact. This isn't like Defenders of Wildlife, where these plaintiffs have never even been to the foreign countries. They haven't even observed the endangered animals, right? They have no actual concrete and particularized injury, right? Well, here the plaintiff does likely have a concrete and particularized injury, right? Failing out of law school, loss of economic opportunity, just the debt that could be incurred from this, right? I mean, there's probably particular and concrete injury there when you're getting kicked out of law school, right? And you have debt and that loss of income opportunity. Hey, look, if I graduated and got my diploma, I could have gotten a job as an attorney. Maybe I earned this amount of money, right? You can calculate some real injury there, right? That is concrete and particularized. The problem for that plaintiff is going to be tracing that injury to the IRS's change in policy, right? Because that's a really attenuated causal chain from the IRS changing this policy, right? From, hey, look, the fair market value deduction on donated goods, we're going to reduce to 10% on deductions. That causes less books to be donated, right? There's a lot of other factors involved there. Why a plaintiff might fail out of law school. Can we really say it's the IRS's fault for this change in policy? That's the reason the plaintiff got kicked out of law school, right? The court is probably going to say that that's too speculative, right? There's a lot of other factors at play there, right? We don't know exactly what this plaintiff was doing, what else is going on here. There's a lot of reasons other than not having the right book you can fail a law school final exam. So it's just going to be very hard to trace. And also just the change in policy alone, right? Is that the only reason that there's less books? That this book the plaintiff needed wasn't at Goodwill, right? It's hard to even show that the policy change itself had an impact, right? Not, and then beyond that, all the plaintiff's conduct too. I mean, it's just too speculative, right? You can see where the problem can be, and plaintiffs challenging changes in policies and actions by the IRS for either tax exemptions or deductions, right? These policies where the IRS is basically changing things a little bit to incentivize or discourage conduct, if that conduct causes an injury, right, to the plaintiff, usually it's going to be hard for the plaintiff to show or at least trace that injury to the IRS's conduct or action, right? So, but anytime on a fact pattern where the causal chain gets attenuated, where it becomes more and more difficult, right? The distance between the injury and the defendant's conduct, the further and further that gets, right? The more attenuated, the more difficult it becomes to show the link between the plaintiff's injury and the defendant's conduct or action, right? That all goes to causation. And if the plaintiff can't establish causation, the court has to dismiss the case for lack of standing, right? The federal court will have to dismiss the case because the plaintiff doesn't have standing. They can't hear and decide that case, right? That's causation. Our third element is redressability, right? And this is the idea that it must be likely that a favorable court decision will redress plaintiff's injury. So maybe one of the most seminal cases here is a Supreme Court decision in Linda R.S. v. Richard D. Right here you have a lot going on, but just to give you the basics, right? Essentially what happens is Richard fails to pay child support to Linda, right? They have a child, and Richard does not pay the child support he owes to Linda. This happens in the state of Texas. Texas has a penal code statute that says if you fail to pay your child support obligations, you can be convicted of a misdemeanor and put in jail, right? So Linda files for an injunction or seeks an injunction to compel the district attorney's office to prosecute Richard and put him in jail for not paying the child support. And there was other stuff going on here, right? One of the main concerns Linda has is actually, discriminatory in that Linda's child is a non-marital child, right? Born out of wedlock. So the Texas district attorney isn't prosecuting because basically that district attorney is saying that this is outside the scope of the statute because it's a non-marital child, right? So that's kind of the underlying issues, but less important for standing. But that's how it gets up to the Supreme Court, right? Based on these discriminatory issues involved with non-marital children. Okay, but the Supreme Court takes a look at it and says, well, the problem here, we can't even get to the merits of the case because Linda, the plaintiff, doesn't have standing here, right? She's suffered an injury for sure, right? Richard has failed to pay his child support obligations, right? That's an economic loss. We can show that very easily, right? We have an injury. The injury is traceable to the defendant, right? I mean, that's as straightforward as causation gets, right? Defendant owed Linda money, didn't pay it. That has now resulted in Linda having economic loss. We can trace the economic loss to the defendant's conduct. Okay? The problem here is Linda is not suing and seeking monetary damages, right? She's out for blood. She's seeking an injunction to compel the Texas district attorney to prosecute Richard D. to have him put in jail, right, for a misdemeanor offense. And the court is saying, hey, look, even if we find in the plaintiff's favor, it's not going to redress her injury. Her injury is mostly economic, right? She hasn't been paid what she's owed for child support. Even if we put Richard in jail, right, we give Linda what she wants, right? That's not going to redress her economic loss. It's not going to remedy her economic loss. So for this reason, Linda lacks standing. We have to dismiss the case, right? Now, if Linda had sought economic damages, right, she's seeking monetary recovery, well then of course, right, in that situation, it would be likely that a favorable court decision would redress her injury, right? If she wins and she gets money, that redresses her economic loss. But because she's seeking the injunction to compel the DEA to prosecute Richard D., they're basically saying there's not enough of a connection between putting Richard D. in jail and her actual injury, right? They do talk about vindication of the child's interest, right? The idea that, well, maybe it does vindicate her to some degree, right? That is kind of one of the underlying pins of putting somebody in jail, right? It's about punishment and vindication for the victim, but they say that's not enough. This idea of vindication, right? It doesn't really go to the interest of the child, which is what this is about, right? When we're thinking about non-payment of child support, that's all about, support of the child. They feel like the vindication here isn't really going to help the child putting Richard in jail, right? So for that reason, the case is dismissed. It lacks redressability, right? The plaintiff Linda cannot establish all three elements. She might be able to show injury in fact and causation, but she can't show redressability because that element is not satisfied. The federal court has to dismiss the case. They cannot adjudicate the case unless the plaintiff can establish all three elements, okay? So these three elements that you see here are kind of what you would call the constitutional standing requirements, right? No matter what, on any constitutional law fact pattern that you see, right? If you see a federal court is going to hear and decide a case, you want to run through these three elements to ensure that the plaintiff has standing to bring this case, right? But beyond this constitutional standing requirement, there are some prudential standing requirements. Prudential basically just meaning judge-made requirements. Right? Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first-year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final, and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.